Good afternoon, everyone, and thank you for joining us and attending our presentation today. For those of you that I have not met, my name is Sandy Haas, Executive Director of UWRA and serving as your host, as your Zoom host today. In addition to our very distinguished speaker, with me today are program coordinators Tom Eggert and Rick Deluge, along with technical support, Jürgen Patow and Don Miner. It is my pleasure to introduce a member of the Committee on Financial Matters and Retirement who is serving as today's coordinator. Please join me in welcoming Tom Eggert for the purpose of an introduction of our distinguished speaker. Okay, Tom, it's all yours.
Thanks, Sandy. So it is an honor to get to introduce Peter. Several years ago, we were sitting in the same place as probably some of you, trying to decide how do we proceed, and shopped around and ultimately found Peter and his law firm to work with us on the development of our trust. Peter's the co-founder and an attorney at Borokoff and Osmond, and their specialization is estate planning and business planning. They're in Madison on the west side. We're all very proud that he's a University of Wisconsin Law School graduate. His focus is in the area of estate planning, elder planning, business planning, and estate administration. So all things that are consistent with the theme of the series that we're doing. He's also a member of Wealth Counsel, LLC, which is a collaborative nationwide network of top estate planning attorneys, and also participates in the Madison Estate Council. When he's not being an attorney or an estate planner, he enjoys golfing, boating, spending time outdoors, traveling. They live in Monona. He's married to his wife, Becky. They have 2 children, and he coaches his kids in youth soccer. So Peter, thank you for joining us. Thank you for working with us in the past, and I hope others can get as much from you as we did.
Great, appreciate it, Tom. Thanks for the introduction and also for the kind words. Look forward to hopefully presenting some relevant information here for the entire group. Give me just a moment here as I share my screen and hopefully do this correctly so that you can all see what we're trying to present here. So can everyone see the presentation? Tom, can you confirm that I did that correctly this time?
No, undo what you just did, because it was correct to begin with, and then you switched into presenter mode. Yep. There you go.
Okay.
Yep.
Perfect. All right. So hopefully everyone can see that intro slide now. And again, I really appreciate everyone taking time out of their day for today's presentation. This is probably one of the most common topics that anyone in the estate planning industry and even some related industries is going to come across, which is, understanding the differences between wills and trusts from an estate planning perspective. And so what we'll go through here today is just some of the mechanical differences and intent differences between wills and trusts. And I'll talk about some ancillary topics related to the differences between them from an estate planning perspective. So as we kind of click past our fun legal disclaimer here, this is really how I intended to break down today's presentation. We're going to talk first about last wills and testaments. We're going to then talk about revocable trusts. We'll touch on irrevocable trusts and the difference between revocable and irrevocable trusts. And then we'll hit some high points at the end, just sort of what factors to consider, or how do clients decide between using a will or a trust when they're making the estate planning decisions and when they're putting all of this into place. So this is kind of just our high level roadmap of what we'll cover here today. Just a reminder, as Sandy mentioned on the front end, please do submit those questions via the Q&A button. That often one of the most beneficial parts of a presentation like this is addressing your specific questions, and we'll make sure to take time to do that on the back end of today's presentation. So getting started here, we'll first start by talking about estate planning when it's centered around a last will and testament. And when we talk about wills versus living trusts, You're going to hear me talk about them as the centerpiece to the overall estate plan. They're going to work in conjunction with the powers of attorney and incapacity documents, but oftentimes a big decision point for a client is, do I want the centerpiece or the central document to be a will, or do I want to use a living trust? And maybe understanding why someone would use one versus the other. So I'd like to start with sort of the mechanics here, the roles within a last will and testament when we think about the structure, right? A will is going to be a document I draft during my lifetime that's going to serve as a set of instructions for how to administer and distribute my estate after I've passed away. And so some of the roles and terminology you'll hear me use: a personal representative. That's the term we use in Wisconsin, but it's synonymous with the role of an executor in other states. That's the person who's responsible for administering your estate, submitting the will to the probate court, and following the instructions, working with the court, the beneficiaries, and the creditors to administer the estate and carry out your wishes pursuant to your will. We'll use the term beneficiary. A beneficiary is a person who would receive assets upon a person's passing underneath the terms of a will. A guardian is a term relevant for those of us who have minor children, and appointing effectively a backup parent, somebody to care for the children and be their legal guardian at any point where they're minors if something were to happen to both of the parents. We'll talk about a testamentary trust or testamentary trustee. Really important here not to get confused that when we use the term trustee or testamentary trust as it relates to a will, this is entirely different in function than a revocable trust or a living trust. This is a trust that is not created until after I've passed away, and it is created only through the terms of my will and through the administration of that will through the probate process. And again, we'll talk about probate. We'll talk about a probate court and its function and role within a last will and testament centered plan. So it's important to understand and remember, when we use the term probate, we're talking about a court proceeding, basically the court governed process of administering the estate and carrying out the terms of the will. Also, as we'll touch on when we get to trusts and PODs and beneficiary designations, when I use that term estate in this context here today, I'm using it in its legal definition form, right? Which means the absence of a person owning the assets, right? So if I own an asset during lifetime in my individual name and I die, that asset now no longer has an owner. The legal default we have is it becomes a part of my estate. And when an asset becomes a part of my estate, it triggers the probate process and therefore is governed and administered by my will if the asset becomes a part of my legal estate. So again, these are just some of the roles, some of the terminology that we'll use in today's presentation as we talk about the documents. So when does a will come into play, and really what is it that we're talking about with a will? Well, a will, we often think about planning documents in terms of when are they relevant. We draft a will while we're alive and well, but it has no impact during my lifetime, and it has no impact during my incapacity. In other words, a will is what we call a death-only document. It only applies once I've passed away, and as I alluded to a moment ago, it only applies as to those assets that are part of my probate estate. It is reactive in that it administers the assets that land in my estate post-death, and it's dependent on that probate process in order to be administered. So upon my passing, if I have a will, my personal representative is going to submit that and admit that to the probate court along with some initial probate documents. And then they are going to work in conjunction with the probate court, the judge, the interested parties, the creditors to administer the probate through that process. They're going to submit the court documents. They're going to inventory assets. They're going to notify creditors. They are in charge of any of those assets that became a part of my estate as a result of my death. So again, a will is a death-only document. Despite the fact that I drafted during my lifetime, it doesn't mean anything until after I've passed away. Some of the elements of a will, you heard me use that term a moment ago, that it's a reactive document. That's because when we draft the will, there's no intentional or current or proactive coordination or identification of assets. It simply is drafting this document, and it's going to be the catch-all for anything that becomes a part of my probate estate. So it reacts post-death to those assets that are there in my estate, and it will become effective and enforceable once I pass away. Important to note, because of that, it is fully revocable as long as I'm alive. At all times that I'm alive, I can always revoke a will. In fact, the will cannot be irrevocable. By its own terms, and by the definitions, a will would be invalid if there was a contractual obligation to enter into that will. So it has to be revocable up until the moment of my death, or prior to that. If I become incapacitated, I can always revoke my will. Some of the nominations we talked about: guardian, personal representative, beneficiaries. You're going to determine your distribution pattern. So this is where I spell out if my kids get assets 50-50 if I pass away, or if I pick a favorite and decide to divide it 60-40. But I'm going to make those determinations in drafting my will as to how to allocate assets. Probably one of the most frequent terms we hear when we first meet with clients is that their situation is simple, and they've already determined prior to talking to us that all they need is a simple will, which is fine. And there are some people who that probably is true for. But one of the questions we like to ask in that first conversation is, what do you mean by a simple will? Who do you want it to be simple for? When do you want it to be simple? And there's no right or wrong answer to this. Some clients truly mean they don't want to talk to me for very long. They want to put as little effort into the planning as possible, and they want it to be simple to draft for themselves, and they want it to be simple right now. But what we find is that there's really an inverse relationship between the simplicity of the drafting of the legal document, will, trust, or otherwise, and the complexity of the administration of that document. Because the simpler the document is on the front end, that means I likely didn't contemplate certain variables or scenarios or what ifs on the back end. And so there may be a lot more complexity to administering a simple document than there would be to administering a more well thought out document. So it's one of the things we often talk to clients about in that first meeting we have with them. And if I'm being totally transparent, most of the time when our clients tell us they're simple or they need a simple document, we figured out that's really just code for the fact that they don't want to pay very much money, which again is perfectly fine. But we want to flesh out what they're getting at, what their goals really are when we're talking about the planning. One of the distinctions I draw with a will, as opposed to some of the other documents we'll talk about, is that a will is a set of asset transfer instructions. It is not in and of itself an asset transfer mechanism. What I mean by that is that it cannot independently distribute my assets, authorize a personal representative to control my assets, or carry out my wishes. It is reliant on the probate court to do those things. In fact, the personal representative doesn't even gain their power to administer the estate, not only until the time when they submit those documents to the probate court, but also until they get the sign off or approval of all of the interested parties, the beneficiaries, the statutory heirs, anybody who is involved as an interested party under a probate is now going to have to sign off and approve of that nomination of a personal representative. So oftentimes we think of naming a personal representative as an appointment or a selection. It is truly a nomination, but still subject to the approval of others after I pass away in order to confirm that nomination. The mechanism, the asset transfer mechanism, is the probate. Again, the will is the set of instructions, but the probate process is the mechanism that can authorize the transfer. And some of the features of a probate are that it's a public proceeding. It's like all other court proceedings. If I die and I have a probate, anyone who wants to can look up what I owned, what the nature and value of my assets are, who my beneficiaries are. All that information becomes public after I've passed away. So again, just understanding the function of a will, it governs the assets of the estate and it transfers them pursuant to the probate process post-death. As we'll touch on throughout today's presentation, it's important to keep that in mind because the fact that a will governs only those assets that are a part of my probate estate means that for most of us, a will is not going to govern all of our assets because some assets may transfer outside of the probate process, even without other planning, even without a trust or any other document in place. And so it's important to understand that in terms of the limitations of a will and really evaluate, well, what assets are going through probate? What is my will governing? And are my other designations aligned with my will or are they contrary? Because as we'll see, if the asset doesn't become a part of the probate, the will has no effect, has no control over governing that asset. So again, just some things to think about when we understand how a will works and how it's actually administered post-death. So we've talked about the term probate multiple times. What is a probate? That's the question, right? Well, as we've alluded to, it is a court-based process, therefore it's inherently public. So not only is the probate court itself and any hearings that occur, not only are they public in nature and that anyone could attend, but more practically in today's world, that means all of the information contained or disclosed in a probate is going to be public via the internet, right? The circuit court access page, same place I can go to figure out if my friends and family members have any recent speeding tickets or other court charges. I can also go there after someone passes away and determine what they owned, where those assets they owned were located, who their beneficiaries are, the addresses of their beneficiaries. This is all public record and public information. So for all of us on the call here today, you know, if we were the ones looking for that information, it would clearly only be for curiosity's sake. But keep in mind, there are those out there who would want to gain that information for less than honorable purposes. And it can be a little bit scary to think about what can be done with all of that information. Probate is a time-consuming process for uncontested estates. This is what our clients would refer to as simple estates. 9 to 18 months is sort of the time range that we put out there for clients to expect a probate to last. The deadline the court sets is 12 months. You can also get an automatic 6-month extension with no purpose or no reason, no explanation. So it can be very time consuming to get through the process. And as we would hear from the beneficiaries, their biggest complaint is going to be the cost. When we've done studies, when we've looked back at probate estates, the average estate spends about 4 to 8% of the estate's value in administering the probate process between personal representatives fees, courts fees, attorneys fees, and other fees associated with administering the estate. And frankly, the smaller the estate, the higher that percentage goes, because some of these fees are just threshold amounts that are going to be charged in that probate process, regardless of size. So one of the terms we've come up with here when we talk about a probate and what it creates post-death is what I like to call a pseudo-democracy. I get to look at a sort of fun slide here to say, what do you mean a pseudo-democracy? Well, a probate gives a bunch of people a voice, whether it's that interested person, whether it's a statutory heir that I disinherited, a creditor, the beneficiary, the court itself. They all have a voice. Now it's a pseudo-democracy because they don't have equal votes. And in many cases, whatever their voice or opinion is, won't actually influence the drafting of the will or the administration of the will according to its terms. But because all of these individuals are given a voice, many of them are given a feeling of power. I talked before about how a personal representative is nominated, but subject to the approval of the interested persons and the court. Well, to overcome that nomination, the interested person would have to have a valid reason that the court deems to be a successful challenge to that person as an interested party and as a personal representative. And so in most cases, these challenges are going to fail because I have the right to do whatever I want in my will as long as I've drafted it validly, had capacity, and wasn't under undue influence. But the court is going to have to hear all of these challenges. The personal representative is going to have to deal with all of these challenges. Just like we often hear about will disputes or contests to the will, or a disinherited family member, contesting the will, very rarely is it overturned unless, again, it was created pursuant to undue influence, or at a time when the individual didn't have capacity. But if they do challenge the will, it's going to create a real headache, and it's going to increase that time delay. It's going to increase the cost of the administration. So that's what we mean when we use that term pseudo democracy. A bunch of people have a voice that I didn't want to have a voice when I drafted the document. If I disinherited someone, I was intentionally trying to leave them out, but the probate brings their voice and their opinion back in statutorily. So again, high level, those are things to think about when we're drafting a will, some of the terms to think about, and also really important and oftentimes a big factor in the decision for clients is understanding how the document's going to be administered post-death, in this case, through a probate court proceeding. So that really brings us, by comparison, to thinking about what is a revocable living trust. Now, you're going to hear all of these terms. You're going to hear revocable trust, you're going to hear living trust, you're going to hear the combination of revocable living trust. They're all talking about the same thing. You might even, if you're talking to somebody who goes a couple of generations back, you might hear the term inter vivos trust. That just means living trust. It's all the same terminology. What we're talking about is a trust document that we're drafting for the purpose of serving as the centerpiece to our estate plan. So when we draft a revocable living trust, just like with the will, let's go back to the vocabulary, the terminology, so that as I use this terminology, it makes sense to us. So by contrast, as we'll talk more about in a moment, a trust is a proactive estate planning tool. It is valid during my lifetime, and we will take some affirmative steps to identify and coordinate assets when we're drafting the trust, which will make a little bit more sense in a moment. But the three important roles to understand in any kind of trust are the roles of a settlor. Settlor is the person who creates the trust. So if I'm drafting the trust, I'm the settlor. If my wife and I are drafting the trust, we together are the settlors. Every trust has a settlor. You'll sometimes hear this referred to as a grantor or a trustor, same terms. It's the person who creates the document. The trustee is the person who has control and administrative power and ownership rights over the assets of the trust. What a trust is really doing is it's creating an entity that divides the rights that a person would ordinarily have as to their property if they were the owner. Think about it this way. If I personally own a bank account, I have the right to control that bank account because it's in my name. So I can choose what bank to deposit it at. I can write checks off the account. I can deposit funds. I can move the funds to a different bank. I have all of the rights of control and management. I also have the right of use if it's in my individual name. I can withdraw the funds. I can spend the money. I can do anything I want. I can use that property as I see fit. A trust divides the rights of control and use between a trustee and a beneficiary. So a trustee is the person who has control and management rights over the assets, and a beneficiary gets to use the assets or gets the beneficial enjoyment of the assets. Going back to my bank account example, if a trust owns a bank account, the trustee selects what bank it's held at. The trustee can deposit funds, can write checks, can pull money out of the account. However, they have to do that for the benefit and in the best interest of the beneficiary or beneficiaries. So the trustee has all of the control, but they do not have the use. The use and beneficial enjoyment is vested in the beneficiary. So as we'll talk about mechanically here in a moment and go into more depth on, by placing assets into a trust during lifetime, I've created now a document that can be administered privately and can eliminate court involvement, can eliminate probate. And we'll talk a little bit more about that concept and touch on it as we go through here. So again, just understanding some of that baseline terminology within a trust. So back to our comparison with the will, how does the trust act, the living trust act from the moment of creation? Well, during my lifetime, I or myself and my spouse, if we create a joint trust, I fill all three of those roles. I am the settlor, I'm the trustee, I'm the beneficiary. By doing that, I retain all of the rights that otherwise would have been divided, right? As trustee, I have control and management rights. As beneficiary, I have the use and enjoyment rights. So when we create a living trust during our lifetime, and we'll contrast this in a little bit with an irrevocable trust, but when I create a living trust, I'm not restricting myself in any way. In fact, other than some change in titling that we'll touch on in a couple minutes here, there's really no change in my day-to-day. My wife and I have a living trust. We use our bank account the same way we always did. We have to pay real estate taxes on our home just like we always had to, unfortunately. But all of those day-to-day tasks stay the same. Now, if my wife and I become incapacitated, we will have named a successor trustee, but we retain ourselves in the role of beneficiary. So here, if we can no longer manage our property, we've appointed someone else to do that for us, but we haven't given up the right to use the property. So that trustee comes into play and they take over and administer our assets for our benefit during our lifetime. Important distinction here, unlike the personal representative under a will, a trustee is not nominated, they are appointed. In other words, if I've named my sister as the successor trustee, or if I've named my attorney or CPA as the successor trustee, if I'm incapacitated, they take over. The only reason they wouldn't is if they refused to serve or were ineligible to serve, incapacitated, deceased, etc. But there's no outside parties that have to approve their taking over as the successor trustee. Now, if we fast forward and my wife and I have passed away, there are successor trustees and there are successor beneficiaries. So my successor beneficiaries, for myself, if I were talking about this, would be my spouse if I died, and our children if we both passed away. And so we would have appointed that under our trust document, and we may have named similar or different successor trustees. In other words, in that example, if I pass away, I probably am going to allow my spouse to continue to be the sole trustee and the beneficiary. But if we both pass away, we're going to want our kids to be the beneficiaries. But at 12 and 14 years old, I'm not sure they're quite ready to serve in that role of trustee, to take over and manage the assets and control the assets themselves. I really would sort of shudder to think about what they would spend it on, or maybe in the reverse, what they wouldn't spend it on. But more seriously, what do we worry about? Well, we worry about how the money is going to be used and the impact it has on our beneficiaries, and are they financially mature enough to manage that property themselves yet? Certainly at 12 and 14, they're not. And they're probably not all that close, if I'm being realistic, right? And that's not a knock on my kids. That's a knock on most individuals, even when they become adults at age 18 or 21. We want to get them to an age where we think we're comfortable with them managing the inheritance themselves. Now, what's the common theme here with this trust? Well, all of the succession events that happened, my incapacity, my death, my wife's death, all that did was change who fills these roles of trustee and beneficiary. What it did not do is it did not impact the owner of the assets. At all time, the owner of the assets was the trust, even when my wife and I were alive. And because of that, even when we both pass away, as we'll talk in more detail about in a moment, there's no probate triggered because nothing becomes a part of our estate. All of the assets were in the trust to begin with, and they remain there even after we pass away. All of the changes internal to the document in these roles of trustee and beneficiary as we've drafted it. So here, I'm not going to spend a whole lot of time on this slide, but when we think about estate planning with living trust, well, what are the potential benefits? We talked about the fact that it avoids probate. I alluded to planning for minor beneficiaries and restricting their access. This can be done through a step distribution trust. This can be done through discretionary guidelines or defined uses of the property. But really what I'm highlighting with this slide is if we take just that simple dynamic of who's the trustee and who's the beneficiary at any given point in time, we can plan for a whole host of common planning concerns by thinking through and potentially segregating the roles of trustee and beneficiary. This is where we talk about things like remarriage protection and blended families. If my wife and I have our assets in this joint trust, and let's say hypothetically she passes away first, I picked her because she's not here. But in seriousness, I picked her because I don't want to make her the bad guy since she isn't here. And so for that reason, if she passed away first, one of the concerns we might talk about is, well, what happens if after she dies, my intent changes or my life changes in such a way that I would want to change the plan, right? We talked about it. If we were drafted wills, I can do that up until the moment I died. And she can't prevent me from doing that because ultimately she can't create a contract or make me enter into an irrevocable will. But with a trust, she could take her portion of the assets and funnel them into an irrevocable share. This is a way she might be able to ensure that the assets are protected for the benefit of our future beneficiaries, namely our children in this case, but restricted from my ability to redirect or redraft that portion of the plan and redirect those assets elsewhere. So if I were to get remarried, I can't pull all those assets out because somebody else might be the trustee of that share, and that share may have become irrevocable at that time. Even more common in blended families, because if I have 2 kids from a prior relationship and she has 2 kids from a prior relationship, the classic concern is that I worry that if I die first, she's going to, come in and redirect all the assets, meet with our attorney and redirect all the assets to her kids, because maybe she never liked my kids to begin with, or maybe the relationship falls off over time because they weren't as close relationally. So a trust can solve for a lot of these concerns simply by understanding how we can manipulate those roles of trustee and beneficiary, and how we can control and change the revocability of a document after I die to become irrevocable and restrict some of those changes that could happen. So again, just some potential uses of a living trust. So one of the things that comes up probably as commonly as anything else is, there's this trust that I've heard about, and I heard that if I have this trust, I have to get the assets into the trust, or I have to fund the trust. That's the term we use here at the office. It's really important to understand that I could draft the best trust in the world. It could be perfect. It could perfectly mirror my client's intentions. But if we don't ever put assets into the trust or coordinate the assets with the trust, then those assets are still subject to probate. It's really simple to understand why, because if the assets remain in my individual name and I die, they are going to become a part of my estate. And as I said before, that's what triggers probate. So if I'm going to draft the trust, it's really important I fund the trust, I coordinate my assets or align my assets with that trust. And that's not an automatic process. In fact, it can be a very involved process to go through and identify all the assets and make sure the deed gets recorded, transferring the ownership from mine and my wife's name into the name of our trust, and that our bank accounts are retitled, and that our stock accounts are all handled, and our beneficiaries are updated appropriately. It's an important thing to be aware of. And it's also important that you get the appropriate advice and assistance. For example, when our firm drafts a trust document, 99% of the time, maybe more than that, we are also going to be involved in the funding process. Our team is going to be involved in drafting the documents to get the assets into the trust and to carry out those instructions and confirm that those actions were taken by the various financial institutions. One of the things we think about is the title controlled versus beneficiary controlled assets. So when we talk about funding or aligning assets with the trust, it is not in all cases transferring the ownership to the trust. Sometimes it is, like in the case of real estate or bank accounts or standard investment or brokerage accounts or stocks. These are title controlled assets, and most typically they're going to transfer based upon who the owner is. So if the owner is an individual, they're going to become a part of my estate and therefore subject to probate. If they are titled to a trust, then the trust is going to govern who the successor trustee and who the successor beneficiaries are internally. By comparison or by contrast, we have beneficiary designated assets. The two classic examples here are retirement assets like 401ks, IRAs, etc., and life insurance policies. These are assets that at the time of death don't transfer based upon who the owner is. They instead have a document or a contract internally with that asset that designates a beneficiary to receive that account or to receive the proceeds from that asset at the time of my passing. So when we have a trust that we've drafted, we want to make sure those beneficiaries are coordinated with that trust, because if I use the example of my kids at ages 12 and 14, if I designate them as the contingent beneficiaries and their individual names, then my life insurance of $1 million is going to pay out $500,000 to the 12-year-old directly and $500,000 to the 14-year-old directly. And those are immediately in their name. And the moment they hit 18, they have direct control and access to everything that came into their name. But if I name my trust as the beneficiary, and in my trust, I specified that up until they reach the age of 30, someone else is going to be the trustee managing the assets. Now I've coordinated it with my planning tool, the living trust, and I've protected my kids from gaining access to those assets too soon. So we talk about trust funding. There is no day-to-day impact. In fact, I guarantee you, if you asked my wife on a daily basis, about how the assets being in the trust affect her, she would probably say, I forgot they were in the trust, right? Because we don't notice it on a day-to-day basis. We notice the little things if we're paying attention. The real estate tax bill is addressed to our trust. Our bank account statement is titled in the name of our trust. But our debit cards and our checks still reflect our individual names. And we spend money, we withdraw money, we deposit money the same way we always have. There's no change in our management or our use during lifetime. And there's no change in other things like tax reporting. It's all tied to us as individuals. It's just the title that's changed. At death, the big difference is that the assets are either already in the trust or they're going to pay directly to the trust or shares of the trust as designated by a beneficiary designation. So that's the high level overview of trust funding and the importance of it in an estate plan. The next slide here, I'm going to talk just for a moment about alternative asset transfer mechanisms. We talked about how probate through the terms of a will is an asset transfer mechanism. We talked about how a trust operates. Well, what else can happen? Well, whether I have a will, trust or not, or neither, I could have some assets that I own jointly. And if I own them jointly in what we call a joint tenancy, or as a survivorship asset, if my wife and I owned our home individually and I died, if we had that titled as a joint tenancy, that's joint ownership with survivorship rights, meaning that she simply files a document with the Register of Deeds and becomes the owner of that home. There's no probate, there's no transfer otherwise. In fact, even if we had a will, if we titled it jointly, that will would be irrelevant when I passed away. So that joint tenancy dynamic or joint ownership dynamic is important to understand. The survivor takes by default, same thing with a joint bank account. Now that's only a temporary solution, right? Because now if my wife and I both die, there's not a third owner of our house, at least not in most cases. And so because of that, that's only going to avoid probate. That's going to create that direct transfer when the first of us dies. You'll hear references to TOD or POD designations. These are designations that can be associated with various accounts. A POD is a payable on death. This is associated with bank accounts and cash accounts because it is saying pay the cash proceeds of this account directly to the named person or persons. A TOD is a transfer on death. Same thing, non-probate transfer directly to an individual, except it's an in-kind transfer. So if I put a TOD designation on my stock account, that stock is not going to be sold and cashed out and then transferred the cash to my beneficiary. They were going to receive an in-kind transfer of the ownership of that stock account. So these are optional account designations in many cases, and they are a direct transfer upon death to named individuals. No probate, but also no regard to my will or trust. And what its terms say if I've just named individuals directly. Not going to spend a lot of time on beneficiary designations because we already talked about this in the context of funding. But again, retirement assets and life insurance, these are beneficiary designated assets that transfer directly to the primary and contingent beneficiaries upon a person's passing. These, to a lot of clients, especially a lot of clients who have yet to sit down and do any estate planning or proactive estate planning, these can be really appealing quick fixes or simple ways to avoid probate. And if avoiding probate is the only goal, these types of designations can be used for most assets out there. In fact, in today's world, you could probably do it for almost every asset short of vehicles, including real estate can have a TOD designation on it. But it's important to think about the comprehensive side of the estate plan. What happens, let's just say hypothetically in my, as I would view it, relatively simple scenario. And let's say we fast forward 20 years. So my kids are now 32 and 34, and I'm not worried about them being minors. If I designate every account transfer on death designated or beneficiary designated equally to my two kids, I skip over any authority of a personal representative or a trustee post-death to administer my estate. What that means is there's no person responsible for or with the control over all of the property to pay my bills, to settle my affairs, to pay the funeral home, to make sure my final tax returns get filed, to pay the final medical bills. And many of our clients are going to respond, or as I might if I was thinking about this simply, and say, well, that's okay, because the kids will have gotten everything directly. They'll just split all of those costs and there won't be an issue. They get along anyhow. And so that shouldn't be a problem. Well, hopefully that's the case. And in a simple and idealistic world, that's great. Now with two kids, maybe it works out. If it's my parents doing this where there's 5 of us, I have a lot of reservations about all of us separately receiving our 1/5 share and then expecting that we're equally going to pay all of the expenses. Not to be any kind of complainer here, but I still haven't gotten paid back from 3 of the 5 for their share of my parents' Christmas present. I'm not terribly worried about the $50 I'm missing for that, but if it was 1/5 of the cost of their funeral, final tax return, final medical bills, all debts and expenses of their estate, I'm a little bit more concerned if there's no mechanism forcing them to pay me back. I would much rather have a trustee or a personal representative have control over all the assets first to pay all those expenses before they've landed in the hands of the 5 beneficiaries in that case. And so again, just understanding these mechanisms and how they could be used, but also if I have drafted a will or a trust, making sure these designations are aligned with my plan, because these designations, if not aligned with my plan, can override my intent. So from there, we're going to transition and talk a little bit, and probably just a little bit, though we can address more in the questions, about irrevocable versus revocable trusts. Well, simply put, the difference in them is right in the title, right? A revocable trust can be amended, changed, or revoked pursuant to the terms of the trust at any time. A living trust is almost always revocable, at least as long as one or both of the settlors or any of the settlors are still alive. I can also put assets into the trust and take assets out of the trust at any time. But really importantly, the settlor, in this case, I'm referring to myself and my wife, we retain control, use, and access at all times. And it's by its revocability, it is flexible enough to change with me and my family and my assets and my planning intent over time. So if we get 40 years down the road and we decide our kids are doing well and we'd rather have our grandkids inherit the assets of the trust, we can do that. We can shift it from 50-50 and have it go 25% to each of our kids and the other 50% divvied up amongst the grandchildren, or however we want to. We can revoke and amend it at any time. As the title suggests, an irrevocable trust cannot be amended or revoked at any time. So that's simple enough to understand. But this is typically a much more specialized or limited planning tool. Whereas a living trust, I'm going to put all of my assets into that trust. I'm going to coordinate everything with that trust because I still have access and control to everything. With an irrevocable trust, it's going to be limited based upon the intent that I'm trying to accomplish. And it's going to be limited in terms of the assets that I might coordinate with that trust. And so with that planning tool, it's very much based upon what I'm trying to accomplish. I might be trying to protect those assets for myself or for others. I might be trying to divest myself of those assets. And there's a lot of different applications of irrevocable trust in that way. Important to note, very different than a living trust. Almost certainly, I will not be both the trustee and the beneficiary of an irrevocable trust that I create from the beginning. And in many cases, I can't be either. I can't be either the trustee or the beneficiary, depending on who I'm providing for and depending on who I'm distributing those assets, depending on the intent of why I allocated those assets to that irrevocable trust. So they're very different planning tools. But before we even, anytime before a client even delves into which one should I use, it starts with a conversation around intent. And just briefly, we have sort of a listing of some of the common types of irrevocable trusts. The motivation and intent of the person creating the trust is a major factor in the planning and in the drafting. So we might create a special needs trust for the benefit of an individual who has some kind of a disability or need that qualifies them for public benefits. Here I'm protecting the assets, not for myself, but protecting them for the benefit of this beneficiary and drafting the terms of the trust to ensure they don't lose access to those public benefits. It might be a gifting trust to provide for children or grandchildren for educational purposes where I'm divesting myself of that property. It could be to protect assets from the nursing home. We get a lot of questions about, using these wonderful irrevocable trusts to protect assets from the nursing home. A lot of those conversations result in clients not necessarily feeling like those trusts are so wonderful because they didn't realize they'd have to give up control or use over the assets. So just important to understand the intent, again, charitable purposes as well. In the questions or as a follow-up, we can delve more into types of irrevocable trusts if there are specific questions. So that brings us to sort of the final portion of my presentation before I open it up to questions here. But how do I decide between a will or a trust? If the presentation to date hasn't really driven you one direction or another, I think it's important to take a step back and say, well, what might factor into my decision? Estate size might factor into my decision. Again, the more assets I have, the more daunting 4 to 8% of my estate being spent on that probate might become. The asset makeup. Do I own real estate and business interests and stocks and bonds? Or do I, am I 94 years old and at this point I live over at Oakwood and only have a checking account and a retirement account to my name? The asset makeup could drive us one direction or another in terms of how to plan. But those are really just the starting points in my mind. It has a lot more to do with me, my family, my intent, and my concerns. What are my priorities when I'm entering into this planning engagement and this planning decision? What are my family dynamics? Who are my beneficiaries? What are their needs? What are their ages? Do I view it as a burden to them if they have to run a probate or administer a probate? One of the questions that came up in sort of our precursor conversation is, well, okay, so if I don't have kids and maybe I don't even have a spouse, maybe I'm a single person with no kids, maybe I'm part of a married couple with no kids. A lot of these things that you talked about don't directly relate to me. Well, what we hear from a lot of our clients in those scenarios is that what motivates them is not burdening anyone else if they were to pass away. Maybe, in fact, if I do have kids, maybe I'm okay with them having to sweat a little and take a little bit of pain to get the assets at the time I inherit because they're the ones getting the money. But what if I'm leaving all my money to charity and I would otherwise be looking to my brother or sister or a friend or other family member to serve in this executor or personal representative role? I might view it as a bit of a bigger ask if they have to run a probate than if I can simply designate that charity under a trust. So Everyone's gonna have different planning tools that fit their priorities and goals. Again, for a lot of our clients, it's that private versus public dynamic. I don't know about you, but most of us don't go around. I certainly don't go around posting my personal financial statement publicly or registering it with the court. So it can be a little uncomfortable to feel that all of that information does become public after I pass away, whether it's just from a pure privacy perspective, or if there are concerns about who can access that information and what they might do with it, whether it's soliciting beneficiaries, whether it's some kind of identity theft or fraud. Those are the types of things that come into our brains when we hear public and private information being shared publicly in today's day and age. And then again, age of the beneficiaries, certainly among those factors as well. Now, whether it's a will or a trust, when we sit down and have this planning conversation with clients, we have to think about what are the decisions and what maybe challenges some of our clients who think their situation is really simple to dive more into the details is who decides where the assets go, who manages the assets, how are the assets allocated or divided percentage-wise, specific gifts, specific assets, when would a beneficiary receive direct access to and control over their inheritance, how will they receive it? You know, this is a conversation that if we had another hour, we could talk about the differential goals of restriction and protection. And then again, age of the beneficiaries, sometimes an alarming statistic, but when they've studied this stuff, they find that beneficiaries who are under the age of 35 at the time of inheritance, on average, spend that inheritance within 18 months. And probably the most shocking part of that is that average is regardless of size of the inheritance. So it's one thing if my child spends a $20,000 inheritance in 18 months, but if it was a $2 million inheritance, I'm far more concerned about what they're spending it on and what the rest of their life is going to look like if they have spent it that quickly. So I'm going to open it up to questions here in just a moment. The slide I'm going to leave it on for the moment is just when clients ask us, when is the best time to plan? This is the graphic I always have in my mind. What's the deadline for planning? Well, unfortunately, unlike filing my tax return, I don't know that I just have to complete my estate planning by April 15th of every year. I know I have to complete it before I become incapacitated or die, but you know, probably for the best, most of us don't know when we'll become incapacitated or pass away. And so your planning opportunity is between now and whenever that first of date of incapacity or death occurs. And this graphic just sort of shows you where the different estate planning documents and tools, where they apply and where they become relevant. So with that in mind, I want to make sure we have time for some of the questions. I think I can tell that some have come in. I don't see them, but I can see the red notification that there are questions. So I'll turn it over to our moderators to go through some of those questions here.
Rick, you want to ask the first one or you want me to?
No, I can go ahead. So the first question is, if a person has two beneficiaries, can I have them sign something that says they agree to the personal representative that I've chosen, so that step can be avoided in the probate process?
Yeah, it won't formally, it's a good step, right? It's a good step to get their intent documented. The court's got its own specific waiver and consent document that has to be signed at the time post-death. And there are requirements that go along with that document that they have to have been presented with a copy of the current will as of the date of the death of the individual that was submitted to the probate court. And they have to have been given the opportunity to challenge that appointment even at that time. So I think it would probably help encourage them to think about the fact that they will have to sign off and hopefully remember that they already agreed to this, but it won't eliminate the need to get those sign-offs and signatures, and it won't change the fact that they could change their mind down the road. The probate court always needs to see that contemporaneous sign-off.
Kind of a follow-up question. Is there a minimum estate size when the probate court says, well, you've only got $10,000, we're not going to worry about it?
Yep. That number is $50,000. That number hasn't changed since the statutes were written. So obviously no inflation adjustment on that from the state of Wisconsin, but $50,000 cumulatively. So it's not per asset. I can't have a bunch of $49,000 assets in different accounts and avoid probate. It's cumulative. So, you know, if we think practically, for most clients who have a checking account and a car, and maybe an investment asset or two, you get over the 50,000 pretty quickly, especially in today's used vehicle market. But again, that's the threshold, 50,000.
Since you brought up cars, a question that was asked earlier was, should cars be retitled and put into the trust or not?
The answer to that is they can be, but they do not have to be. And the reason for that is they shouldn't have to be. Any client who drafts a trust, most attorneys will, and they definitively should, draft a document called an assignment of tangible personal property. This is a direct document that recognizes that certain assets like the coffee table in my living room and the bedroom set and the china that I inherited, they don't have documents of title. So we generically assign them to the trust, but we do that with all of our tangible personal property. And from a legal perspective, automobiles, boats, ATVs, recreational vehicles, those are all considered tangible personal property. So the assignment of personal property will cover those items. Some clients choose to put their cars in the trust. Our rule of thumb is this: if you have cars already, don't retitle the cars that you currently own, because A, they're depreciating assets, and B, you're going to have to pay a new registration fee to the DMV. Secondarily, if you're buying a car and you're financing it, don't put it in the trust, because most of these promotional financing companies, very streamlined and straightforward, they'll get all panicky if you mention a trust. So if you're buying a new car with cash, you could put it in the trust. But even then, the DMV can be a little bit tricky to work with. That might not be the first time you've heard that. But again, we don't typically put cars into the trust, but they can be.
Can you talk about the process for designating an insurance policy benefit to accrue to the trust that then would be used to take care of final expenses? So how would you?
Yeah, great question. So the process is, depending on the insurance company, I'm either going to request the beneficiary designation form, or for many assets now, I might have an online account and I'm going to click on the tab that says change your beneficiary or update beneficiaries. And you're going to provide there, instead of the spouse's name or instead of the kid's name, they're going to type in the name of the trust, the date the trust was created, who the trustees are, whatever information they request. So it's either a change of beneficiary designation form or it's an online change. It's actually one of the things that maybe highlights why do we, as our law firm, what are the reasons we get involved in the funding or the asset coordination with a person's trust? Is because otherwise those would be all the questions individuals have. Well, you told me to name it as a beneficiary. How do I do that? Now the life insurance company sent me this 15-page beneficiary designation form just to designate the beneficiary as a trust. What sections do I fill out? How do I answer this section? And it's not that I don't think most clients could complete that. I think it's within most folks' capacity, but having the determination and the follow through to get through the follow-up forms, the requests, and make it all happen is really uncommon. And if it doesn't happen, we have that probate exposure, which diminishes the value of the trust planning we put into place. So since there isn't a standard answer, it depends on the institution. That's just highlights why it's important to have someone walking you through that process.
Can you just run through just the process again? I know you talked about it earlier, about how do you designate bank accounts and real estate to a trust?
Yeah, bank accounts and real estate, preferred manner of designating them to the trust is retitling. So with a home, we deed it from our individual names into the name of our trust. There's no transfer tax. There's a recording fee of $35, but you record it and the new owner becomes the trust. Same thing with bank accounts. We prefer that the titling gets updated, that we submit a letter or instructional form to the bank and say, update the title from Peter Osmond and Rebecca Osmond into the name of the Osmond Living Trust. Now I say those are our preferred methods. Some clients don't like their bank accounts in the trust. And why don't they like their bank accounts in the trust? Just because. There's no really specific legal technical reason, but they like to think of their bank accounts as theirs. It's their operating money, it's their day-to-day money. So some clients will resist us on that. That's fine. We would just designate the trust as a payable on death beneficiary for those bank accounts to ensure we're avoiding probate. Some financial institutions are trickier than others. And not picking on them here, this is just the trend we've picked up. Larger national banks and local credit unions can be resistant to titling an account in the name of the trust, especially credit unions. If the individual also has debt accounts at that institution, it's tied to the fact that credit unions identify the accounts by a member and a member number. And they want that member, if it has debts, to be a person that they can attach to for those debts. And so we've run into some of that with local institutions like Summit Credit Union and UW Credit Union. Again, it's not a problem. We have a backup strategy, but from a cleanliness perspective, we'd rather have them in the trust. And why? It's not just that we're sort of stubborn, because if they're not in the trust from a titling perspective, then we lose that incapacity management by the successor trustee. They don't get into the trust until after death. So we do mitigate a little bit of the comprehensive value of the trust if we can't retitle. But again, it's not the end of the world.
I have another question about, can part of the estate be TOD or POD and another part be in the revocable trust?
Yep. When we get that question a lot, the answer is it can be. Now, again, if you ask me what my preference is going to be that it all flows through the trust, because that's the best way to plan for all contingencies. For example, what if we had assets in the trust and some TOD'd, and then during our lifetime, we spent down all the assets that were in the trust and only the TOD assets remain? Well, now I've removed that trust and the trustee authority from an administrative perspective. So that variable is out there. Also, if I POD accounts, if it's one or two for a specific reason, that's fine. We have plenty of clients who do that. But the maintenance of that plan over time becomes more significant if there are accounts that are POD'd. What happens with new accounts? Are they in the trust or they POD'd? What happens if one of the POD beneficiaries dies? The trust would have contemplated what happens with the beneficiary share if they died. A POD or TOD doesn't always accurately or appropriately contemplate what to do with that asset if the person who is to receive it was to pass away. So again, it's not a no, you can't do that, but we would want to discuss the reasons, the goals, and the risks if we leave some of the assets POD or TOD.
There are a number of questions that are just looking for resources, Peter. Resources on how do you go about funding a trust? Is there, besides this PowerPoint, are there resources that you would point somebody to, or resources on how to help married couples without children decide who or what to leave assets to? I mean, generally, I think people are looking for other resources.
Yeah, there are other resources. There's a website actually called estateplanning.com that is meant to be public facing and provide some of those resources and the answers. The tricky part is, and that website is no different. The tricky part is that so often the answers are more customized than they are generalized. And so while we can provide general insight into how do you fund a retirement account, how do you deal with a life insurance policy, how do you deal with bank accounts and real estate, there are nuances to many client situations. And so most of those resources are going to stop short of saying definitively, you always do this or you always do that. One of the examples I use is there are people out there in the public sphere, attorneys, financial professionals, and otherwise, who will say in two extremes, you can never designate a 401k or an IRA to a trust, or you always designate a 401k or an IRA to a trust. And the truth is they're both wrong. There is no never and always in estate planning. There are trusts that are drafted in such a way that you cannot designate 401ks or retirement assets to them because they haven't drafted in the language that specifically deals with those tax deferred assets. If a client asks me, I would tell them, yes, all of the trusts we draft can have that retirement accounts designated to them, but they don't have to be. Again, we could decide what we're going to leave the 401k separate. We deal with that differently on the beneficiary designation. So there are resources out there. But what's problematic, and this is not a dodge of the question, what's problematic is so many of those resources that you'll find, even if you Google this stuff or just browse the internet, it's either focused on selling you on a different product, or it's focused on trying to coach someone through doing this all themselves, which still often ends up in a product sale through a legal Zoom or things like that. And the problem from my perspective is that for most of us, and it's not true for everyone, but for most of us, there's just more complexity than we're going to be able to work through without some guidance from somebody who can evaluate our situation and make recommendations. Now on the other point, the question about, individuals without kids, whether it's single or a married couple, and who to designate. One of the things I tell everyone, even our married clients with kids, is there's no right or wrong answers in estate planning. There's no, you can't do this, you have to do that. And so I often want clients to take a step back and free themselves from the feeling of expectation or entitlement that can come from children, can come from siblings or other family members. If I don't have kids, parents, etc. It doesn't have to be any of those people. It could be friends that are meaningful in your life. Could be charitable organizations that you've supported during life, or even ones that you wanted to support during life but didn't have the extra cash flow. If you're considering charitable organizations, even though we don't want to tell you there's too much homework, I think it's important to do your research, understand what the organization supports, how long it's been around, how the donated dollars are used internally and externally. There's a bunch of good websites out there that rate charitable organizations and provide some of this insight, but sometimes it's just a matter of calling the organization and setting up a call as a potential donor to understand what they do with the funds. And then again, other individuals in your life, free yourself up to think about, it could be just about anybody, and it doesn't have to be any specific person or groups of persons.
Okay, Peter, on another kind of two-part question here. What does it cost usually to set up a trust? Or is there any kind of a annual fee in having set up a trust? And then what are the tax implications of moving assets into the trust, especially if they yield income?
Great questions. I'm going to deal with the last part first so that I don't skip over it, because the other one I can walk you through. But the tax implications of putting assets into a trust during lifetime are zero. It is a tax neutral event because a living trust, a revocable trust, is identified by the settlers who created it and their social security numbers. So after I create my trust and put assets into it, the next year I file taxes the same way I always have. I report all of my income on a 1040 tied to my social security number. Literally nothing changes about tax reporting, and there's no differential tax impact when you put assets into a trust during your lifetime. You also don't forego any of the tax benefits at death that are associated with individuals owning assets. The assets of a revocable living trust are as if they were owned by the individual from a tax perspective. It's what we consider a look-through tax entity or a pass-through tax entity. The cost question is one that I always like to address, and I like to address it very transparently. But keep in mind that in that transparency, this is me answering it as to what we see with our clients when we draft trusts, and there is inherently variation within that. So I'll start with a generic answer because we get these phone calls all the time. I want to draft a trust. How much does it cost? And they want me to answer that question and then call the next attorney. And so the answer I'm going to give that client is that a trust for an individual or a married couple could cost anywhere from around $3,000 up to $9,000 or $10,000. Now, that's not the end of my spiel, so don't worry, I'm not dodging the question. Again, I want to be transparent. It's a really broad range and it's incredibly unhelpful. And I'll say that to the person on the phone as well. What drives the cost of a trust, at least at a firm like ours, and at many in the Madison area and beyond, is the complexity of the planning and the complexity of the documents. So I'll always immediately follow that up and say, the top half, maybe even the top, 3/5 of that range is really reserved for clients who are doing taxable estate planning, meaning they would otherwise be subject to estate taxes. And therefore, they're doing advanced planning to avoid those estate taxes or to mitigate or minimize those estate taxes. Most clients, a very reasonable estimate is between $3,000 and $5,000 for their entire trust-centered estate plan. Some are going to be a little bit above that. Some are going to be a little bit below that. But it depends on, again, the complexity of the documents and how much work goes into coordinating the assets. Many firms, again, we're not the only one by any means, but many firms are like ours in that they will bill a fixed fee that is quoted before the clients have engaged the firm. In other words, we first spend time meeting with the client, evaluating their situation, understanding their goals, and making recommendations. And thereafter, we will propose a fee and they can determine, yes, let's move forward. No, we're not interested. Or in some cases, well, that's more expensive than I thought. How can we reduce the fee? And we'll talk to them about what elements of the plan could be modified or removed in order to reduce the fee. So, to me, the big key when you're working with an attorney is transparency. What I don't want to be as the client is I don't want to sit with the attorney who tells me what their hourly rate is and then gives me an estimate and says, but we'll see how many hours it takes. To me, that's not a very productive engagement, and it leads to oftentimes unmet expectations and more billing than anticipated. So, I would, if I'm the client, I'm going to demand transparency on the front end so I have some control over what that cost ends up being.
Can you talk about choosing trustees? So choosing a trustee that's a family member, how do you choose among different family members? If it's not a family member, how do people pick the trustees?
Yeah, so this is going to be the preview or Cliff Notes version of that answer because we've done entire presentations on trustee selection, and it's a big part of our conversation with some clients. But I'll give you the high-level overview. There's three categories of trustees that we think about. There's what we call individual trustees, there's corporate trustees, and there's professional trustees. An individual trustee is any one of the following: my child, my sister, my cousin, my neighbor, my old law school professor. Those are individual trustees, right? So I'm selecting somebody, an individual that is a part of my life. The upside to an individual trustee is they probably know me fairly well. Hopefully they know what types of decisions I might have made during my lifetime. And they have some of that interpersonal context when making the decisions. The downside to most individual trustees, or the potential downside, is that most of our cousins and siblings and kids haven't gone to trustee class and haven't been trained in how to be a trustee and don't necessarily have the qualifications, or in some cases, unfortunately, the skill set to fulfill that role effectively. This is not to say they're a bad choice, but keep it in mind. What are the professional skill sets, qualifications, et cetera, of the trustee? And what are the dynamics between the trustee and the beneficiary is going to be like? Again, personal example here, but if my kids are the beneficiaries and my sister's the trustee, now she's not just Aunt Christie, she is Trustee Christie, and she's the bank, and she's that evil woman who said no when I asked for money for spring break. And now when I see her at Christmas, I'm not going to sit on that side of the table because my kids are upset at her for not giving them money that she shouldn't have given them. And so there is a blend of family and money depending on the plan, depending on who's involved, depending on do I have kids that are minors or not. where we might be blending interpersonal and family and or interpersonal and money. And at least in a lot of our experience, that's not always the best combination. But there are plenty of situations where an individual trustee is used. And sometimes it's simply because we do have a good fit in the family. Or as I think we've heard the example before, in clients we've talked to, I've got 2 kids, I'm going to make them co-trustees and they're going to have to figure it out. Okay, that's perfectly fine, right? And at least they're equally empowered and they're going to have to work together. A corporate trustee would be naming a bank or a professional trust company. This is naming a corporate entity whose job is serving as trustee. So they certainly have gone to trustee school. That's not necessarily a real thing, but you get where I'm going with that. They've been trained on this. They have professional expertise, and they're going to know the ins and outs of what it means to serve as a trustee, both from a liability perspective and from a responsibilities and duties perspective. So a corporate trustee can be attractive. There's 2 primary complaints that come out with a corporate trustee. The first one we can all predict, right? Well, if this is their job, they must charge a fee, and that fee must be pretty substantive. It is, in the grand scheme of things, it's not the end of the world. They typically charge a percentage-based fee. On average, that fee is in the range of 0.5% up to 2% of the trust assets. That's not inconsequential for most trusts and estates. But if you look at it in the reverse, if I can have a professional company handle this, and all it's going to cost my kids is 1% of the net inheritance, that's actually probably not a terribly bad deal either. And none of my family members have to curse my name after I've gone because they're burdened with serving as my trustee or executor, right? The other complaint, and I think it's maybe more valid to think about, or more important to think about, is they don't know the family. They don't know me in the same way. They don't know my kids necessarily. And so it's not to say that that precludes them from being a good option, but it may impact how I draft the plan. I may put a lot more of me, so to speak, and my preferences and my guidelines into a trust that's drafted for a corporate trustee to administer versus my sister, who's known me since the day I was born, and I think has a pretty good idea of types of decisions I might make. The third category is a professional trustee. It's sort of a blend of both. We have clients who ask us as the drafting attorney to serve as the trustee. We have clients who name their CPA that they've been working with for 30 years. We have clients who name other professionals, financial, banker, et cetera, that they think have professional expertise that they can leverage. In a perfect world, this is a blend of the individual and corporate, where it's somebody with professional liability, expertise, and knowledge in terms of the role, but hopefully some knowledge of the family or the individual, or even if we don't know the family, if I'm the drafting attorney, for example, I have insight into the intent of the clients when they drafted the document that might go beyond the printed words on the pages of the trust. Again, there's no right or wrong answer here. It's sometimes is an in-depth conversation, and sometimes it changes over time in terms of who's going to be a good fit. The one element I would typically encourage clients to remove from the evaluation is the trustee fee. Because I'll tell you this, in our experience, Uncle Fred is just as likely to charge a trustee fee of 1% as the bank is, right? Because when he gets done administering the trust, that's the question he's going to be asking the attorney and everyone around him. Well, what do I get paid for this? Because that was more work than I expected. So I would take the fee component out of it and think about the other dynamics.
Okay, we're getting short on time here, but I have another question. I have just become a personal representative of a person who has only financial assets without transfer on death action. If there had been a transfer upon death, who would pay for her not planned funeral costs, final home care costs? Luckily, I can pay from her assets during the probate process. But if all assets avoided probate, from where would those last expenses come?
The best answer to that question is who knows, right? Somebody is going to have to pay those expenses. Presumably the recipients of the TOD and POD and beneficiary designations are going to acknowledge their responsibility to pay those funds. And hopefully, unlike my example of myself and my siblings, they're going to pay them equally. That's what That's what the intent should have been, but it doesn't always play out that way. And the point you highlight with that question is the point I hammer home to all of our clients. In fact, when I have clients who are determining whether they're going to use a will or a trust, and they say, well, it seems like I can get all this probate avoidance with TODs and PODs. Why would I do the trust? I'll just do that. I'll be very frank with them and tell them I'd rather see you do a will and have a probate proceeding than TOD and POD everything. Because even if a will isn't ideal for many clients and in many scenarios, it does ensure that, as the question alludes to, the personal rep can pay the funeral bill, can pay the final nursing home bill, can pay off the creditors. So to me, a TOD POD strategy, except in very rare circumstances, it is a Band-Aid and a workaround. And I'd rather see it as part of a comprehensive plan that was thought through than as just I went off and slapped a POD on everything I had and called it good for estate planning.
Another short question is, does a non-spouse beneficiary of a primary residence receive a stepped-up basis upon death?
Yes, everybody does. As long as that asset was includable in the person's gross taxable estate at death, which is, I know, a longer answer than the question implied. But any transfer of assets, real estate, cash, securities, business interest, they receive a stepped up cost basis at the time that a person passes away, as long as they transfer through their taxable estate and transfer by operation of their death. Just for context, this is different than if I gave my house away during lifetime. If I deeded my house to the kids, another popular simple fix, especially when it comes to Medicaid and nursing home planning, clients will say, what if I just deed the house to the kids? Well, amongst other problems that we don't have the time to get into, they now receive carryover cost basis. They receive the parent's original cost basis in that property rather than the cost basis being stepped up to date of death value. So when the parents who bought the home when they had their first child in 1972 deed that house to the kids, those children get the $20,000 of cost basis the parents have in that property, not the $280,000 of current market value. And the impact is that then when they sell that house that was gifted, they're paying capital gains taxes at 20% on $260,000. They could have paid 20% of $0, which to me, not even though I'm not a math major, still seems like a better deal.
I've got two questions that both relate to, sort of your role. First one is, how do you guys work with trustees? So people have died. Is there some ongoing commitment, ongoing relationship to help the trustees that now have this responsibility go to trustee school or manage the trust or learn what their obligations are?
Yes, that is a role that we can play and many attorneys can play. And just pausing for a moment, because I do realize I neglected one part of the fee question, which was ongoing or maintenance fees of a trust. The answer to that is no, a trust does not inherently have any ongoing fees, any annual filing fees or maintenance costs, other than the cost to update and maintain the plan over time. That oftentimes is just a matter of clients calling in, asking for an update and the firm quoting a fee. Many firms, or at least I shouldn't say many, some firms, are self-included, do offer an alternative option where some clients choose to pay an annual fee to the law firm to make the law firm proactively responsible for reaching out about updates in the law, changes to the plan. And those types of annual fees often, if they're paid annually, then contemplate updates to the documents themselves not being billed out separately. Again, we get into more details, but I want to be clear that there's no ongoing maintenance fee associated with the trust. Many of our clients, even probably most of our clients, simply call us when they have changes. And if we need to make changes, we'll quote a fee at that time. To the post-death side, yes, we will meet with the executor, the personal representative, the trustee post-death. And at a minimum, we'll often host a meeting that's simply focused on telling them what their roles and responsibilities are, walking them through what to expect and what the process looks like and what happens post-death and what their, again, rights and responsibilities are as trustee. One of the most typical sort of bad trustee perspectives to take is that a trustee thinks, well, I'm the trustee. That means what I say goes and I have all the power. Sure, but you're also a fiduciary as to the trust and the beneficiaries. And so you have all that power, but very, very much limited by the instructions of the trust document and your fiduciary duty to act in the best interest of the beneficiaries. So a lot of trustees and personal representatives will hire us to represent them through the administration to make sure they don't violate any of their duties and create liability for themselves, to make sure they don't do anything they're not supposed to. But on the flip side, to protect them against the allegations or the claims or statements of beneficiaries, right? So when we get the beneficiary, the child who shows up at the funeral and asks the trustee, where's my inheritance? I expected it by now. And again, not a made up story, really true situations we've seen where people are looking for inheritance that soon. The trustee has an attorney who can follow up and say, actually, distributions are going to be several months out. We first have to pay all the bills. We have to make sure that we filed the tax returns, et cetera. So a lot of clients will hire an attorney in a post-death context if they're the trustee. And depending on the law firm and depending on what the client's looking for, that might be some kind of an hourly billing relationship, or in many cases, it can actually be a flat fee that's quoted based upon the scope of the work agreed to between the attorney and the trustee. So if you do name an individual trustee, don't feel like they have to be on an island. Don't feel like they have to, you don't have to give them you don't have to send them an email that says, I named you as trustee and here are all the recommended books that I want you to read before I die, and here are all the classes I want you to attend, right? They can hire professionals. They can hire a CPA to file the tax return. They can and should hire an attorney or a realtor to sell the house. They don't have to wear all the hats. They just have to make sure all the tasks get completed.
The related question is changing a trust. So the question came in, we've had a trust that's been in existence for a long time. They had identified a successor trustee that now isn't really appropriate as the successor trustee. They would need to come in and amend the trust. What's involved in that? And then another question was, how frequently do people amend trusts?
Good questions. It could be in that scenario that it is as simple as drafting an amendment that revokes that specific provision as to the prior trustee designation and replaces it with a new trustee nomination provision. In many cases, if there's a difference between if it's been a couple of years and a couple of decades. Oftentimes we find that that when clients come in saying, I've got to change this trustee and that's it, there's either other changes in the document that they weren't aware of needed to be changed because they didn't think through all the successions and the contingencies and the provisions, or there are changes in the law that would impact other provisions of the trust, which might result in that trust being restated in full rather than simply amended in part. Also, from a practical perspective, I'm not going to shock anyone on the call by saying attorneys themselves tend to be a little bit liability averse and conservative in decision making. If I drafted a trust, I'm much more likely to be willing to simply amend that trust and accept and approve of the other terms of the trust. If it's another attorney's trust from 17 years ago, I'm going to be more likely to explain to the client that I can't certify that the rest of that trust is still in good shape and shouldn't be touched. And so I'm more likely to recommend a restatement. Even if it's my own trust from 17 years ago, I'm more likely to suggest a restatement because there's been changes in the law, changes in our drafting over that 17-year time period. So timing and source of the documents can matter. And did I miss a part of that question? I want to make sure I didn't.
No, I think that's right. But I guess the question then would be, how often should someone come back and meet with you to see if there have been changes in trust law or standard practice or whatever?
probably a good rule of thumb historically is 3 to 5 years is a good time frame to keep in mind, that at least we should look back at the plan as a client and remind ourselves of what we did before and make sure the nominations are correct and that our family and assets and lives haven't changed too much. Certainly after 10 years, you're going to want to have it reviewed, even just from a legal perspective. What I tell my clients though, because again, liability averse, I don't want them to hear a time range and hold me to it. I tell my clients they should review it annually. That does not mean, just to be clear, that you have to pay your attorney every year or they have to redraft the document every year. But at least get the plan out, look at the summary documents, make sure that things haven't changed. As we probably all know, just from our own day-to-day lives, a lot can change in a year. And if I don't make something an annual habit of taking a look at what I've done, it's a lot harder to remind myself that, oh yeah, I only review my trust every odd year, or I only review my trust every time, it's a leap year. Those are harder things to remember. And so if it's an annual practice, we tend to be less likely to forget to do it.
Next question is, what is a pour over will?
Great question. It's one of those few legal documents that sounds exactly like what it's called. A pour over will is a backup document to a living trust. And very visually, if we think about it, if I forgot to put an asset in my trust, the pour over will is going to grab that asset and it's going to pour it over into my trust post death. Now that sounds all well and good and simple, but a pour over will is still a will, meaning that if I have to rely on my pour over will to get an asset into the trust, it's going to require a probate of that asset if the asset is greater than $50,000. But it's a backup tool to the trust.
He had another question just on costs. And I know it's hard for you to answer specifically, but the question was, all right, you had mentioned probate costs between 4 and 8%. How does the cost of drafting a trust to avoid the 4 to 8% probate cost compare? Are they comparable? Are you coming out ahead? Or what size estate you come out ahead? Or
I would say 90+% of the time, the cost of a trust over the life cycle of the document, including the post-death administration, is the cheaper total all-in cost than the will. Because if you think about those percentages and then go back to my prior comment, let's just say on the high end, I spend $5,000 putting my trust into place. Well, if we do the math and say, even if I spend most of my money, and I get it all the way down to where all I have left is my house and $100,000 in savings, I still probably have a $500,000 estate, at least for most of us. And even if I was really efficient and I kept my probate costs all the way down at 2% of the total estate, I'm still spending 10 grand on that. And so I'm spending more on the probate in almost every case than the drafting of the trust. Now, again, that's life cycle. My client who tells me that I don't care what happens after I'm dead, it's not my problem, isn't going to care about the probate cost, right? They're going to say, well, I don't see any benefit in that. Why would I pay money now if I could just have my kids pay money later? Perfectly fine response. That's a perspective that clients can take, which goes back to my statement. Nobody needs a trust. A trust is something I decide I want because it fits my planning goals and my interpersonal goals.
just a really quick question. Somebody asked, can the trustee and the beneficiary be the same person? And I think the answer is yes, but you want to just comment on that?
Yep, and really in every scenario, right? When I create my living trust, I'm the trustee and I'm the beneficiary. When I die, if I had one kid, I could name them as the trustee and the beneficiary. They could administer the trust and distribute everything for their own benefit. And then again, more of the subject for, I think, the third part in this series on the post-death administration side. I could even have the assets that my kids inherit stay in an ongoing trust for their benefit, even once they've been distributed to my two kids. And I could even say that, well, as long as my kids are 30 years old, they could then serve as the trustee and beneficiary of their own share, meaning they have full control and access. Again, topic of another conversation, but The benefit to doing that is now those assets are not part of their personal and marital estate, and so they're protected from their creditors, their liabilities, post-inheritance, including things like divorce, lawsuits, and bankruptcy. So that's the long way to say yes, the trustee and beneficiary can be the same person.
So Peter, a question, this is just sort of a clarification question. When you were talking about irrevocable trusts for nursing homes protection, the question is that to protect the assets from being used up until they are gone, or is it to protect the family or the remaining individual from the state or having to use your assets up before Medicaid takes over?
Yeah, it's some bit of all of those things. And depending on how I wanted to phrase this or sell this, I could tell you one of two things. I could say it like this. I could say, that's for you to put your assets into to protect your assets from the evil nursing home that's coming after all of your assets. And this way, you don't have to spend all your hard-earned dollars on nursing home care. Your kids can still inherit your home and all of your assets, and you're still cared for by the nursing home. So I could phrase it in terms of protection. I could also take the alternative position and say, this is to make sure your kids get all of your money and you have none. And so you have to rely on the state and the Medicaid program to provide for your final years of life and pay for your nursing home care. I actually said the same thing in both scenarios, and they're both true. But what I'm getting at here is back to the intent and the motivation. Any client who comes in and asks me about a Medicaid trust or a nursing home trust or divesting to an irrevocable trust, I'm going to ask them what their goal is. And they're going to say protection. I'm going to say protection for who and from who. Well, the from who is easy, from the nursing home or from the state or whoever their bad guy of choice is. The for who is a little bit more nuanced, because they'll say, well, what do you mean? I'll say, are you protecting it for your benefit or for your kids' benefit? Now they're going to say both. Okay, but then I'll tell them they can't choose both. They have to pick their priority. Because when we divest assets to protect them from the nursing home, we are restricting them from ourselves. Okay, it's very simple, right? Everyone knows the phrase, you can't have your cake and eat it too, kind of applies here. You can't restrict the nursing home from accessing your funds and allow yourself to have access, right? That's too good to be true. And as we know, unfortunately, when something seems too good to be true, it probably is. And that's the case here. So if the client says their primary goal is making sure their kids have an inheritance because it means something to them to leave a legacy and provide for their kids, okay, let's discuss the Medicaid trust, the irrevocable trust a little bit more in detail. If they say, I don't care about inheritance, I was planning on spending every dollar I ever made. I just don't want the nursing home to have it. I want to protect it from myself. Now we have a different conversation at hand because we can't really do that, right? We can't have access to everything we own and also put up a wall only as to the nursing home or our creditors. And so it's just important to think about who we're protecting for and when we want it protected and prioritize. Again, just part of the conversation.
There's a question about funding of trusts. I think maybe a little more clarification on this topic would be good. Are there any resources we could file that really spell it out, how to fund a trust?
Yeah, they're public resources that they're inconsistent. You can get some of this if you delve into some resources that the State Bar of Wisconsin has on estate planning and funding. You can get resources from that website I referred to, estateplanning.com. You can also get resources from the institutions themselves, right? So if I have an account with Schwab or if I have an account with Fidelity, they're going to have resources on retitling and retitling to trusts. But again, it's hard to find consistent, reliable public forum resources for this. But the place to start is to evaluate the asset. Is it title controlled, like a bank account or real estate or a stock? Or is it beneficiary controlled, like a retirement account or a life insurance policy? Again, I don't mean, I'm really not dodging the question. It's just hard to find those public resources that are reliable and consistent. But if you turn to the institutions where the assets are held, they're going to have that information. If I have a trust and I go to my bank and I say, I need to get this into my trust, they're going to know what to do. Or if the first person I talk to doesn't know, they're going to connect me with their manager or the branch manager to assist.
So we're in a marital property state. How does marital property work with both trusts and wills? We had a question on the role of being in a marital property state in a trust where one settler has died and the other one is still alive. Is there even a role for marital property considerations at that point?
Yeah, there's, Wisconsin's marital property law is, it permeates everything, okay? And that doesn't, I don't mean that to be negative, but it really influences everything that a married couple does, or in some cases can do with their property. And if we all had our calendars cleared until 5 o'clock, I could talk through this all in depth. But again, hitting the high points because I want to address the question. Marital property law operates independent of trust law or will law. Marital property law is really specifying who has the right and control and access to property during a marriage, right? But then that does inform who has the right to transfer the assets or a portion of the assets at death, which then ties into the estate planning. So most trusts that are drafted, for example, are going to state that they don't override the marital property classification of property that was owned before the trust was created. If it was marital property when I put it into the joint trust, it's still marital property. If it was my individual property before I put it into the trust, it's still my individual property. Now there's a tracing and tracking issue that goes on here that is incumbent upon the attorney and the client and the team around them to make sure they trace appropriately, but it does operate independently unless I drafted the trust to say that everything that goes into this trust is marital property, which could happen as well. Although you run into some state law issues if the clients start moving to different states and acquiring other property. But as it relates to a will and a trust at death, I can only control and direct what happens at my death with my assets. And if we apply the simple default Wisconsin marital property law for the married couple who wasn't married previously and owned 2 nickels when they got married and accumulated everything during their marriage. Okay, let's take that simple couple for a moment. You assume everything is owned as marital property, therefore you assume each spouse has control over half. That means if I die, my will can only direct up to half of the total assets. Now, there's a further limitation with a will because it might not ever land in my estate. So it's actually far less than half that I can control if it's jointly owned, if it's beneficiary designated, et cetera. With the trust, I can control up to half, which means that if my plan is doing anything other than leaving all of my assets to my spouse, so if I'm restricting my spouse's access to a portion, if I'm leaving some directly to my kids from a prior marriage, the maximum amount of the trust assets I can direct is half. And the other half, it doesn't matter what I want to do because those weren't my assets to begin with. Those are my wife's. And I don't get to say, I died. Hey, wife, here's what you have to do with your property. Or I can't take it away from her, so to speak, right? So marital property is an important consideration for all clients, not just Wisconsin residents, because people move, right? And live in different states with different state laws over time. People live in Wisconsin and own property in Florida because they don't like the weather this time of year. I can't necessarily blame them. But again, the concept here is we have to pay attention to property ownership, marital property or otherwise, when we're drafting an estate plan.
This is sort of a follow-up to that in a way. The individual is asking what can be done to prevent an unscrupulous, greedy, newer spouse from concealing a trust with a wealthy older spouse with adult children from his first marriage, subsequently refusing to disclose whether the decedent's biological children are designated beneficiaries, given that the trust is considered a private document.
Yeah, this scenario is something that hopefully, if it is a concern, we've addressed on the front end of the drafting, right? In other words, hopefully, I didn't draft a trust for, I'll use myself as an example. Hopefully the attorney didn't counsel my wife and I to draft a trust where if my wife died and I'm the survivor and then I get remarried, where that new spouse has any role in the trust. In other words, shouldn't be the trustee, shouldn't be a successor trustee, shouldn't be a beneficiary. So from a legal technical perspective, we prevent them from being able to keep that information from the biological children by making sure they can't become involved in the plan. Now, in some cases, either because the clients don't think it's a concern or because they don't want to add the level of complexity, the following scenario can occur. My wife dies, I inherit the money. I get remarried, I know my new spouse isn't supposed to be part of that trust, and I'm doing well, I'm keeping everything separate. And then my capacity starts to decline. And then my new spouse, who's just trying to take care of me, walks me into the attorney's office, and we talk about how she should really become involved. She's taking care of everything. She needs to know where the bank accounts are. And by the time we walk out of there, maybe at my preference and direction, or maybe due to her influence, now she's been named as a trustee. Or even if she hasn't been named as a trustee, she kept me as a trustee, but she's practically controlling my decision-making in reality. There it becomes a little bit trickier for those biological children to protect their rights, especially if, in my example, dad is still alive. Now, if I pass away, those beneficiaries have rights and there's going to be a successor trustee, but it all goes back to the original drafting and the current dynamics. And trust, will, or otherwise, the one thing that we cannot 100% protect against without what many clients would call over planning is protecting against the unscrupulous new spouse. I think that's how it was described, right? Because if they're willing to bend the law, break the law, conceal documents, ignore the terms of the documents, ignore the incapacity of the spouse, there's only so much we can do if someone's really willing to go outside of the law and the documents. But I think if that example is anyone's personal example, it really does, as uncomfortable as it may be, it's got to start with a conversation with the biological parent from the kids to figure out where these documents are at and what's supposed to be happening, if it's possible. If it's not, and I'm not a fan of suing people or necessarily estate litigation, but if you really are getting stonewalled, you got to try to contact mom or dad's attorney and understand where the documents are and describe the situation to them.
We had a couple of questions on how setting up special needs trusts for addicted heirs. Can you just sort of talk a little bit about why you would use a special needs trust and how it might work for an addicted heir?
Yeah, so a special needs trust, or really a trust of any kind for the benefit of a beneficiary who has substance abuse problems, can be crafted in ways to limit, restrict, or even turn off their access to funds if they are currently experiencing substance abuse. Discretion can be given to the trustee to evaluate and determine those things. Most trusts, again, we talk about backup provisions. That's why when our clients ask us, why is our trust so darn long? We explain to them it's because we have to predict a bunch of scenarios that we don't know if they will occur or not. They're often going to contain a substance abuse provision or a spendthrift provision to limit access in those scenarios. And if that's the case, then we want to think about the drafting. If it's known that there's a substance abuse issue, we might get creative in the incentives and say, well, if the trustee uncovers evidence of substance abuse, they're going to turn off distributions, except that they can make distributions for rehabilitative services or to provide care or healthcare expenses for the individual afflicted with the substance abuse. There can be incentive provisions to motivate additional distributions if a person is, quote unquote, clean for a certain length of time. And so there's a whole host of ways that we can get creative with the planning and drafting to account for that person. And it may be as extreme. I say extreme because a special needs trust is a very tightly controlled drafting. It may be as extreme as drafting a special needs trust. It may be a little bit more in between. It may be just drafting a trust where that child can't ever take over as their own trustee. It may be where they have to be 60 before they can take over as trustee. We even have trusts that provide stipulations of proof of sobriety for a certain length of time before a child can access funds or take over as their trustee. So again, there's a lot of flexibility. One of the most attractive aspects of a trust is the sky's really the limit in terms of how we draft the trust and what issues we can address, because it's a private contractual document. It's not a will. It's not governed by the probate statutes, and so really we can accomplish just about any of those goals or concerns.
Switching over to the will side of things, and this was a question I really didn't know was even a question, but apparently it makes a difference which county you probate a will in. And is that true? And how do you know which county to probate a will in?
Well, the second part of the question is the easier one to answer. The county you probate a will in is either, if the person's a resident of the state of Wisconsin, you probate it in the county in which they were domiciled at death. Not necessarily where they died, right? If I die in Sauk County, but I'm domiciled here, it's still a Dane County probate. Or if I'm not a resident of the state of Wisconsin, but own property here, then it's in any of the counties in which I own property in the state of Wisconsin. That's the jurisdiction side. That's the simple one. It shouldn't make a difference which county you probate in terms of the legal outcome. But the reality is, because probates are court-based administrations, they rely on court officials, and one court official may be different in terms of interpretation, leniency, strictness, interactions with the personal representative may be different than another. I'm not gonna badmouth any county, but there is a county to the south of us that has a probate court commissioner who thinks of himself in much higher esteem than every other court commissioner in the county, because he has more legal expertise than them. And this is a direct quote. I've been told this by him on the phone. And that's why his standards are so high for probate documents that are submitted there. Whereas you'll find, for example, I think Dane County has a very friendly probate court overall. They're very personal representative friendly in that they will answer questions, and they can't give you legal advice, but they try to help you find the legal advice. Whereas that county to our south we've experienced them holding a personal representative in contempt, but not telling them what they needed from them. Or what needed to be done, because if you're the personal representative, you're just supposed to know it. So again, very much county to county differences, but they shouldn't be that way. It's just the same as, a certain county might have a more friendly take on certain criminal offenses, or might have judges that lean more plaintiff side, defendant side. That's really what you're dealing with in terms of the differences from county to county. The law is the same throughout the state.
Well, Sandy, I don't know, are we about at the end of our time?
According to my clock, you have about 3 minutes.
Okay. There is one question here about the probate process. They're asking, what is the process for a personal representative to initiate probate?
So the process for a personal representative to initiate probate at a baseline is to file the original will with the probate court in the county that applies based upon that prior jurisdiction discussion. And along with that, file a set of initial probate paperwork with that county to get sign-offs from the interested parties, to alert the court as to the nature of the assets and the scope of the probate, and to empower the personal representative, once approved by those interested parties, to take their initial actions. The state of Wisconsin does actually have a pretty comprehensive, what they call a personal representative's guide to an informal probate in Wisconsin. If you Google that term or any portion of it, you'll probably find the link to the PDF. Again, it's a personal representative's guide to an informal probate in Wisconsin that walks you through all the documents and forms and what needs to be done. We get clients who complain about the length of our trust documents. Well, the length of that document itself is quite significant. It looks like maybe we hit the end of our time here.
I'm thinking so.
Thank you very much for this great presentation.
Absolutely. Thank you all for hosting this, and appreciate all the questions that came from the group and the work of the moderators to share those. Those were all good questions, and I'm glad we had such a large audience. We often don't get nearly that scope of questions, and we often don't get that good of questions, quite frankly. So it's a great group you have here, and I'm happy to have been able to share this time with you guys.
Well, we certainly do appreciate it. Peter, a round of applause from yours truly, and I know everyone on the call. I learned a lot. I know I will be re-listening to the videotape just to formalize some of the stuff that I heard. So thank you again for your time, sharing your skills and your expertise with us. Thank you to Tom and Rick for moderating this presentation, to our audience for attending.